Chapter 3, Video 3, or Part 3. Okay, so we're talking about the process of bringing a case to trial. We're focusing mostly on civil cases now, so unless I mention otherwise about a case, we're probably talking about civil cases. So one of the things that has to be kept in mind from the beginning of a case is settlement considerations. And in doing so, lawyers and their clients, through lawyers, have to make an analysis of the costs and benefits of bringing a lawsuit. How much is it going to cost? How much time is it going to take? What are the funds of the client that are going to be used to do the case? What's the likelihood of winning or getting a resolution that's worth the effort? If you're a plaintiff and you're bringing a lawsuit, one of the important things to consider is, even if you win, will you be able to get paid? Does the defendant have any money? Do they have insurance? Okay, those are some of the important considerations. Another consideration in many cases is, or should be, the relationship between the parties. Is the relationship going to be permanently hindered as a result of the lawsuit because it becomes very adversarial? So in a family law situation, that's a consideration. Where you have parents who are going to parent a child or more for many years and need to get along somewhat, is the litigation going to harm that? Or in a business situation, if you're suing your supplier for something, are you going to be able to get supplies elsewhere if your supplier says, well, the heck with you, you sued me, I'm not going to provide you with the supplies you need to produce your product? Okay. So the next thing is what we call pleadings. Pleadings are the documents that start a lawsuit. In a civil case, the document that starts a lawsuit is normally called a complaint. Occasionally it's called a petition. And the answer or the response that's filed by the person being sued is called an answer or a response. Now, there's two systems of pleading that have developed over the years in our country. The oldest one is called code pleading. The other is called notice pleading. Code pleading is the old system. It's still used in a few states. All the other states have adopted notice pleading, and the federal system was the first system to adopt notice pleading. I don't want to get into too much depth of this. It's more important historically. Note that Georgia is a notice pleading state, and of course the federal system is notice pleading. But the old system required very specific factual allegations be put in the complaint. So complaints, when drafted, were long and extensive. And if you didn't put in enough facts, or the correct facts, to state a cause of action, which we mean a right to sue under the law, then you could be thrown out of court in what was called a demurrer, D-E-M-U-R-R-E-R. And so the defendant would file a demurrer, and the court would say, sorry, you didn't plead the necessary facts, you're thrown out. Well, that was deemed to be extremely punitive and not necessarily good justice for people who are trying to use the courts to right a wrong. So the modern system is notice pleading. And theoretically, in notice pleading, the plaintiff, when bringing a lawsuit, does not have to plead all the facts specifically. All you have to do is state enough of the facts to put the defendant on notice of what you're suing about. Okay? So you can simply say that the plaintiff and the defendant had a car accident on July 1st at the intersection of 5th and Main, and the defendant was at fault. Okay, you don't have to go into any more specifics than that in order to meet the requirements of notice pleading. Now, there are some exceptions to that, such as where it's fraud. There's some recent Supreme Court cases dealing with some very specific areas in the securities industry, etc. But basically, that is the rule in notice pleading. Okay, so notice pleading then created what we now call discovery, which is the process by which the parties can learn the facts of the case both from the other party and from anybody in the public, the government, individuals, businesses, etc. And there are various discovery devices that we will talk about. So discovery kind of makes up for the requirements of pleading specific facts, because theoretically in discovery you'll be able to learn all of those facts. And the general idea is that when you get to court in a notice pleading state with the use of discovery, you should not be surprised by anything that's presented at court. On code pleading, it was the opposite. In code pleading, a lot of learning of the facts that were not learned from the pleadings themselves were learned during trial, and there was a lot of surprise. So I like to draw an analogy here with what we're trying to do in modern court proceedings. And so I talk about what happened when I was in 8th grade in my science class, and I had a wonderful teacher named Mr. Swanson. And in those days, at the front of the class, we had a big table, a sink, and a bunch of other things. One day we walked into class, and there was a whole setup with beakers and things like that. I was a little bit early to class, as were some others. And so we turned to Mr. Swanson. We said, "Hey, Mr. Swanson, you going to do an experiment today?" And he turned to us and he said, "No, I'm going to do a demonstration." Okay, so what's the difference in a demonstration and an experiment? In a demonstration, you know what's going to happen when you do something. So when he adds two chemicals together in class and they cause some smoke, and he knew that, that's a demonstration. If he adds two chemicals together and has no idea what's going to happen, that's an experiment. Now, how does that relate to this? Code pleading was like an experiment. When you went to court, you didn't know what was going to happen. Notice pleading is a demonstration. When you call a witness to the witness stand and you examine that witness, ask that witness questions, you're not doing an experiment. You're doing a demonstration. You know what the witness is going to say. In fact, lawyers are trained that if you don't know the answer to a question, don't ask it, because you might be surprised and it might be an answer that hurts your case or even ends your case. Okay, so that's an important distinction between those philosophies, and modern courts are supposed to be notice pleading and no surprise. Now, the reality is it doesn't work 100%, and there's many reasons for that. I'm not going to get into it. And there are also detractors who don't believe that this system is as good as the old system, would like to go back to the old system, and so they're constantly trying to make changes to make it more like the old system. Okay, so we're going to stop there and we'll pick up with some of the pretrial proceedings.